let me just do it this way. I'm denying the motion for directed verdict on all counts except I'm granting a motion for directed verdict as to count 59, count 60, and count 62. I do not believe that the elements of, that even viewing in the light most favorable to the prosecution, there's evidence upon which a rational trier of fact could find the essential elements of possession of those particular items.
If you're new, make sure y'all hit that notification bell, that like, share, comment, and subscribe. Grab a seat. We finna dig deep.
Yo, the judge just went left. Did she just bink, 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 bink? Did she just hit the state? I'm talking about bink, 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 bink. Did she just bink the state? Not once, not two, but three? 3 counts dismissed from the case? Man, y'all subscribe to the channel. If you're not subscribed, definitely tap that like button. If you're new to the channel, definitely appreciate you for being here. Hit that notification bell so you won't miss a drop whenever we drop. Man, the judge just made this ruling in the case and phew, talking about a smack in the face from the state. In my personal opinion, this was only one wish that only one person could grant. This is a birthday wish that could actually change the outcome of this actual trial altogether, especially when it comes to Yak and even SB. Y'all know the vibes. Grab a seat. We finna dig deep.
Morning. I join in all of those that he does. And we are moving for a directed verdict on each of the counts against Mr. Kendrick. Counts 1, 2, 50, and 57 through 63. And I'll go through each of those in order.
All right.
We're also moving for a directed verdict as to those overt acts that are before the 5-year date, before May 10th of 2017 in the indictment. Based on where we're looking at the jury instructions and the law, my understanding is that the jury is going to have to find at least one overt act that occurred after May 10th of 2017.
Right.
So I believe it would just be extra work for the jury and potential confusion if they were to sit there and go through each of the overt acts before May 10th, 2017. I understand that the state is allowed to put those into the indictment for a number of reasons. I understand that they like them in, or they want them in there in order to be able to quote unquote tell the whole story of the alleged racketeering activity. But since none of those overt acts can be used to support the any racketeering conviction, I don't believe that those overt acts prior to May 10th, 2017 should be before the jury for a decision.
To be fair, man, we've watched this case go on for almost over a year and a half, maybe close to 2. And we've seen the state introduce a whole bunch of different forms of evidence, pieces of evidence, incomplete, complete, wrong, misrepresented, misinterpreted, all in front of the jury, all in front of the judge, in front of the courts, in front of the nation, the defense. And man, ask yourself this, was this actually karma coming back?
Jury, such that a rational trier of fact could find the interrelatedness that's required for those predicate acts. Regarding count 2, the murder of Donovan Thomas, again, it's been a year. I could be leaving things out, but from when I have looked over the evidence that's been presented in this court, what I have seen them present, the state present, is Mr. Kendrick at a Texaco station inside of a Pontiac. And inside of the Texaco station, this Texaco station is a block from the location of the murder of Mr. Thomas. And they show Mr. Kendrick in and out of the Pontiac. They show him in a conversation with someone that may be in an Infiniti. But when Mr. Kendrick leaves the gas station, he's in a Pontiac. There's been no testimony at all, nothing, no video, no evidence that Mr. Kendrick somehow moves from the Pontiac into the Infiniti. And the Infiniti is what is alleged to have done the drive-by shooting of Donovan Thomas. There's been testimony from the state's own witnesses. I believe they presented an Infiniti identification expert that was able to identify the car that goes by as an Infiniti. It is not a Pontiac. Mr. Kendrick is not in anything other than a Pontiac. What else is the state presented? They have interviews that various individuals gave with law enforcement. I believe they have interviews that they've presented in the form of video of Kenneth Copeland on June the 10th, 2015, speaking with law enforcement. They have interviewed, they have the plea agreement from Mr. Sledge. And by the way, that plea agreement from Mr. Sledge does not identify Mr. Kendrick specifically. And they also have Mr. Zachary's interview with Detective Thorpe. But in the case with each of those witnesses, when they've gotten on the stand, and the Sledge one is less important, I'm not going to focus on that. But Mr. Copeland, and Your Honor saw this, repeatedly told the jury that he lied to the police. He said anything he needed to say to avoid putting on that blue jumpsuit that Mr. Shart so desperately wants to bring into the court and show to the jury. He would finesse the police. He would tell the police what they wanted to hear. He would sprinkle grains of truth into his stories to lend them credibility with the police officers. But when he took the stand, he completely renounced everything that he said previously. Mr. Sledge, as you well know, also renounced much of what was in his plea agreement, although, again, that plea agreement does not focus or even, I believe, mention Mr. Kendrick. And then again, Mr. Zachary renounces what he says on the stand. So I think that a rational trier of fact could not find that Mr. Kendrick had any involvement in the murder of Donovan Thomas. Last, Your Honor, counts 57 through 63. All of those counts relate to the activity, the raid on Jeffrey Williams' house on May 9th, 2022. Each of those counts is either specifically gun or a gun count or a drug count, or they're predicated on a gun count or a drug count. There has been zero evidence of Mr. Kendrick in actual possession of those guns or drugs. I'm sure the state will argue that he was in constructive possession. And I'm assuming they're going to argue this because they have two pictures from Mr. Kendrick's phone that were on his phone, that were modified on his phone on May the 9th of 2022. There's been no testimony presented that those pictures were taken by Mr. Kendrick. The only evidence that has been presented is that those pictures are of the inside of the house. So, but let's assume he's inside the house, even if you want to make that assumption. There's been no evidence of constructive possession because there's been no evidence presented of any intent or ability or intent of Mr. Kendrick to exercise control of either the drugs or guns in that house. Zero on intent and zero on his ability to access those weapons and drugs.
You see how dirty the state was being? Y'all was still gonna use this evidence against these last two defendants, right? To push the RICO overt act. We get it, but guess what? It doesn't even go together. Just like y'all didn't catch him in possession of the actual firearms, you actually didn't catch him in possession of any of the actual controlled substance. None of this stuff, he wasn't even at the residence. And speaking of the residence, is it illegal for a person that's not a convicted felon to actually have firearms at their residence? And I'm talking about Young Thug. Now, it's even more interesting. The state knows that he's not even a convicted felon, but they still tried to use this evidence against these last two defendants. But why did Doug actually bring up the statute of limitation? Because the state let you see that they're taking everything they can based off this RICO conspiracy and trying to tie it into one small investigation. But what about the statute of limitations? Let's dig.
First, with regard to the ruling on the motions for directed verdict. So both the state and the defense requested and have gotten a trial in this case before a jury. Is not before the court as a bench trial. So that means that this court is not the trier of fact. And the standard, as you all know, for a motion for directed verdict is not the beyond a reasonable doubt standard, that what the jury is going to be determining the facts on when the case is given to them. The standard at the stage of motion for directed verdict is that all of the evidence is to be viewed in the light that is most favorable to the prosecution. And doing it in that way, looking at it in that way, is there any evidence from which a rational trier of fact could find the essential elements of the crimes that are charged? So with regard to the motion for directed verdict on counts 1, 2, trying to do these in order. Now, let me just do it this way. I am denying the motion for directed verdict on all counts except I am granting a motion for directed verdict as to count 59, count 60, and count 62. I do not believe that the elements of, that even viewing in the light most favorable to the prosecution, there's evidence upon which a rational trier of fact could find the essential elements of possession of those particular items. Let me say that with regard to counts 1, I'm sorry, not count 1, counts 2 and 49, again, is not a beyond a reasonable doubt standard that the court is required to employ in determining a directed verdict as to those counts. I understand the arguments, but it is up to the jury to determine credibility of witnesses, and it's up to the jury to determine what witnesses or what parts of testimony they might believe and what witnesses or parts of testimony they might not believe. So if there is evidence presented that a jury chooses to believe, which is how I have to take it in evaluating this, I have to evaluate it as though the jury is going to believe whatever is most beneficial at this point.
Hey, now this judge, in my personal opinion, made a definite fair ruling, and it was actually shocking to me as well, because I was actually sitting back trying to understand what the state really had up their sleeve. But man, like I said, the state's biggest thing that they did was play it on verbiage. We witnessed it when it came to their own witnesses, and we also witnessed it when it came to the witness pleas. Now, make yourself understand this. Why did the judge actually have to come through and actually make sure that the state's verbiage was actually correct? We seen a whole bunch of different things that were introduced on some of these actual defendants, and they had no direct connect. Now, even more interesting, did we not say the yak wasn't even in possession of the firearms, not even in the home? It was even testified on the stand. This man wasn't even there. He ran, right? So how can you introduce this and put this actual evidence that's being used in this defendant's hand? Didn't make sense from the beginning, but they just let you see that the state was really being underhanded. Now, we actually sat up and watched exactly what happened. The defense made these arguments and the judge just snapped. My personal opinion, this is a birthday wish that Yak can never forget. This is basically like the judge giving him a second chance. And not only is this beneficial for Yak, but you talking about conspiracy. You talking about the overall impact of the actual trial in the case. Man, this could really be the difference maker when it comes to SB and his fate, especially when it comes to this case. Why is the state actually still trying to compile information and evidence for stuff that's not even being used? It's just to paint the narrative to the jury and leave the people confused. Let's dig.
If we're going to allow all the whole list of overt acts on the indictment to go back to the jury, I would ask.
Well, not the ones that y'all decided there's no evidence of.
Right, but the ones outside the statute of limitations, I would ask that on number 6, it's committed an overt act on or after May 10, 2017, or within the applicable statute of limitations.
True.
Yeah, the only thing I'd point out is you've got that later.
I do.
And so, I mean, I agree it has to be somewhere. The question is where.
Well, I mean, the idea with listing out the elements is when they're deliberating, they can go right to that and go, all right, here's what we need to be thinking about.
Which is why I think Mr. Schartz suggested edit is useful.
So I had written down the dates. It's like between May
would be May 10th.
10th of 2017 and May 9th of 2022?
No, it would be within 5 years of the date of the indictment.
No, but let's
Right,
give them the dates.
why not just give them the date? Why make them do math?
Yeah.
All right.
Nobody wants to do math here, we're all lawyers.
The calendar in my head wasn't functioning properly.
Yeah, the indictment, the original indictment was what, May 9th? Okay, so,
If that captures that 5-year window, we had no argument.
okay.
But the indictment doesn't, the indictment says, said accused together with unindicted co-conspirators in the state of Georgia and county of Fulton. You mind if I said?
Go ahead.
On or between the 24th day of January 2013 and the 8th day of May 2022. So maybe the cutoff
Okay.
date should be the 8th day
So
of
then
May.
May, what would that be? May,
May 8th, 2022.
no, for the beginning, May 9th,
Oh, it would be
2017?
May 9th, 2017.
Actually, May 10th.
No,
Because the-
I do
the
too,
indictment-
May 10th. I don't think they're,
Yeah, the indictment came out May 9th.
and May 8th, and honestly, the dates don't, and I'm saying May 9th, 2022.
Your Honor,
Yes,
the evidence demonstrates the conspiracy continuing after that. The evidence that's been admitted demonstrates the conspiracy continued after that. That's
so what's the law on, is it within 5 years before the indictment, or is it within 5 years before the indictment?
it's before the indictment is what the cases say. I mean, if you look at, I believe it's Conzo,
But
that's the case. And
continuing on up until the jury gets the evidence.
yes.
Well, I would disagree with that just because it's specifically pled
yeah.
in the indictment. It says, in the RICO charge, it says, for the said accused together with unindicted co-conspirators in the state of Georgia, county of Fulton, on or between 24th day of January 2013 and the 8th day of May 2022.
Yeah, and with that,
Lawfully conspired.
and with that specific date in there, I would think that anything after the 8th day of May 2022 should not be considered.
And before we dig deep, ask yourself this. If these defendants actually beat this case, how does that look when it comes to the face of the state? So let's keep it G. In my opinion, the defense actually needed that favor. They needed that actual ruling, especially when it came to SB. Because, man, the state is still building that case off of conspiracy. Now, even more interesting is they still haven't proven the unaliveness of Big Nut or Mr. Drinks. So ask yourself this. If these defendants actually walk, what are the victim families supposed to think? Are they supposed to actually trust the state? Or does the state have a lot more at play when it came to this case? So let's dig. Now, was the judge's ruling fair? Absolutely. Is it about time that the judge actually got some order in his courtroom? Absolutely. Has the state been completely running out of control when it comes to this case, the evidence, the witnesses, and what they present? Absolutely. So in my opinion, it was actually good to see the judge actually get order back restored in the courtroom, snatching some of this loose control from the state. The state has definitely been out of control. Y'all using evidence and information against defendants that's not even connected, but we get it. Conspiracy, right? Now, we seen the defense. They actually came up here and made a whole bunch of actual legal arguments. And ask yourself this, were they actually correct? Did you see the prosecutor's face? They all sitting over at the table scrambling and scraping because they don't understand what just happened. What just happened is the judge just gave Yak an actual birthday wish that he should never forget. This case actually should go to show that, man, you got to pay attention to what you post, pay attention to the people you know, and pay attention to everything that you do going around, especially when it goes to social media. Watch your text messages. Stop incriminating yourself. This whole case should be just a learning lesson for not only the people that are watching, but all those that are actually involved as well. You think any of these defendants actually learned their lesson? Now, even more interesting, let's dig a little deeper. Do you think that with this judge making this ruling, with this direct verdict, snatching some of that control from the state that they can't use against these defendants that would have been legally illegal, do you think that this will actually impact the case? Will these two defendants actually walk because of the judge's ruling? Not in favor of the state. Man, y'all jump in the comments, let me know. What will the jury actually say? Will both of these defendants walk? And will they be home before Thanksgiving Day? Man, y'all jump in the comments, let me know y'all's thoughts, especially how the judge did the ruling. And then to watch the state still sit up here and send this old head up here to do what? Fix more verbiage on the paper? Sir, sit down. The case is over. Now, y'all make sure Y'all jump in the comments, subscribe to the channel if you're not subscribed. Tap that notification bell so you won't miss a drop. And remember, we all sitting back, try to watch and wait on this verdict watch. Until next time, the greater the height, the greater the weight. This case should go to show the life you save might be your very own. Till next time, as always, gone.